Hi, I'm Anna Denton-Jones, and this is a series I'm making for Refreshing Law on the new employment bill that was announced in October 2024. I've made a previous video talking about the removal of the 2-year waiting period before somebody can claim unfair dismissal. It's likely to happen in October of 2026. Alongside that, we're going to need to learn some new language. So many of you have probably got probationary periods, and you'll be thinking of a probation period as a period of time in which contractually you've arranged with the employee maybe to have a different notice period, where they're having to prove themselves in the role and you're maybe reviewing and taking a decision as to whether they pass and whether they stay and accrue a longer period of notice. All of that is unchanged. You can still do all of that. It is up to you to decide in your contract what you have around it, and you can continue to do what you do at the moment. Alongside that, the bill introduces something called the initial period of employment. And we've talked about how people will from day one be able to bring unfair dismissal claims. This new initial period of employment creates the ability to follow a sort of lighter touch approach when it comes to the procedure that's expected of you. You'll be used to the idea of, depending on what the potentially fair reason for dismissal is, whether it's a redundancy, whether it's health and capability, whether it's somebody's performance, whether it's misconduct, and we're into disciplinary procedures, that for each of those kinds of dismissal, whether it's illegality, whether it's some other substantial reason, that there are sort of tried and tested methods that have grown up since the 1970s, where the tribunals have set out for us, this is what a fair dismissal looks like. These are the procedural steps you're going to have to take in order for your dismissal for those reasons to be fair. So it's the sort of second hurdle of unfair dismissal. We've got the having a potentially fair reason for dismissal, and then we've got the procedure that we have to follow as well. This introduces the ability in certain types of dismissal, so not redundancy. Redundancy, you're going to have to do full Monty procedure. But for other dismissals, so conduct, capability, illegality, some other substantial reason, if it's in an initial period of employment, then the process can be shorter, easier than the traditional case law might make it outside that initial period of employment. Now, I can hear you all saying, well, what's the initial period of employment? That's going to be set by regulation. The government have indicated that they think 9 months is the appropriate time, but that's subject to consultation. That may well get tweaked, higher, lower, who knows. But let's just imagine it's 6 months, 9 months. Inside that period, the employer can follow a slightly shorter period, shorter process rather, an easier process, maybe a quicker process than what they would have to be doing outside of that period. Now, if you're as old as me, you will remember the statutory minimum procedures that we had and that got abolished. I think we're probably in that territory, something redolent of what happened then. I think we'll have almost minimum procedures backed by some kind of ACAS code that will tell us what process is expected in this initial period of employment. In terms of the in terms of the legislation, there's been talk about it including having a meeting with the person before a decision is made. So we're probably talking fairly basic stuff. No mention, for example, of appeal yet, but that is something that I imagine through consultation might get added. So the person who is being exited from an organisation will have the right to a meeting at which any concerns about their performance or their conduct or what the business background is for the decision will be explained, and of course they'll have the right to be accompanied at that meeting as well. There is talk in the legislation, the door has been opened, if you like, to there being a different compensation regime for failure to follow that initial period of employment process compared to the basic award and compensatory award that we're all used to, which of course is capped at a year's salary or £115,115 at the moment in terms of general unfair dismissal. So you may have a lower fixed, if you like, tariff for failure to follow those processes. In terms of preparation that we can start making, I think we can start thinking about what our probationary period processes look like. If I was going to mark us generally, I would say we're really bad at diarising these things. We're really bad at remembering to get round to having the reviews, and we could probably just make that a little bit slicker. So that would be where I'd be focusing my energy until we've got more detail. If you've got any questions, it's adenton@refreshinglawltd.co.uk. Thanks.